introduction. Courtney is going to give an introduction for Professor Leahy, and then we'll turn it over to our speakers. So thank you all for being here today. We have a small group here in person at the law school and then some on Zoom as well. And so I will be introducing Professor Blackman. Professor Josh Blackman is a professor of law at South Texas College of Law in Houston, who specializes in constitutional law, the U.S. Supreme Court, and the intersection of law and technology. Professor Blackman has written 3 books. His most recent publication is An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. Professor Blackman clerked for Judge Gibson on the U.S. District Court for the Western District of Pennsylvania and Judge Boggs on the 6th Circuit. He's a graduate of George Mason Law School. Professor Vermont is an internationally recognized expert in criminal law, national security, and terrorism. He serves on the 7th Circuit Court of Appeals Committee on Patent Criminal Jury Instruction and is a part of the American Law Institute. He's on the faculty advisory board of the Center for Civil and Human Rights. He's been selected as a fellow of the National Academy of Public Administration and has been selected to serve on the United Nations Expert Group on Public Correction. Here, he served as Dean of Academic Affairs from 1998 to 1999 and taught courses in criminal law, international criminal law, national security, forensic evidence, the death penalty, and wrongful conviction. He's the faculty advisor for the Hispanic Law Student Association, and he's a frequent speaker on campus. He recently spoke at the ACS event processing the events January 6th. It's my pleasure to introduce Notre Dame's own Professor Leahy. We'll turn it over to you as well.
Okay. Thank you so much. It's a pleasure to be here virtually at Notre Dame. I'm sorry I can't be there in person. I visited about 1.5 years ago, and it was an absolutely excellent visit. And I'm sorry, though, my friends at Notre Dame, I can't come visit, but soon enough we'll be in person. We scheduled this event maybe about 2 months ago. And at the time, we didn't know there would be an impeachment. But here we are. In about 27 minutes, if my math is right, the impeachment proceedings will begin in the United States Senate. This is a rare occurrence to have 2 impeachments in the span of 1 year. And there are a lot of constitutional issues here. And I hope today Professor Leahy and I can unpack them and hopefully make sense out of what's going on. And I don't expect to resolve everything, but we'll do our best. So there are about a dozen constitutional issues that I want to talk about. There are more I could, but I'll stick to about 12 of them. Let's start at the very basics. What is a standard for impeachment? The Constitution gives a couple examples: bribery, treason, and this catch-all provision, high crimes and misdemeanors. What does this provision mean? There is a long-standing debate that did not begin with Donald Trump over what high crimes and misdemeanors are. There are 2 general schools of thought that exist today, or maybe I should say 3 general schools of thought. The first was articulated by Jerry Ford when he was the speaker. Future President Ford said, a high crime misdemeanor is whatever a majority of the House says it is, right? So if there are 51% of the House thinks that something's a high crime misdemeanor, that's what it is. I don't accept that formulation. Maybe Professor Leahy does or does not as well. We can talk about it, but I think that there's something more to it. The second approach looks to history, that this phrase high crimes and misdemeanors was formulated long ago, and it drew on a British common law tradition of impeachment, and that there were certain offenses that were known that amounted to an abuse of power. Okay, and Congress has a large amount of latitude in defining what those high crimes and misdemeanors are. There's a third school of thought, which again is not new. It's that only established crimes, right? Only statutory offenses can be a high crime misdemeanor. And I think President Trump's counsel, Alan Dershowitz, articulated this view during the first impeachment trial about 1 year ago. All right, so there are these 3 schools of thought over what a high crime misdemeanor is. Okay, so why are we actually here? The article of impeachment, which was adopted in January, about a month ago, concerned three areas of conduct, which they sort of merge into one, but I want to unpack. The first area of conduct concerns the president's behavior from leading up to January 6th. So basically everything from election day until January 6th, and perhaps even before election day, but it's the stuff that came before January 6th. The second area of conduct concerns the president's conduct on January 6th, which was a speech he gave at the White House Ellipse. Now, you may not have been to D.C. The White House Ellipse is basically a park that's adjacent to the White House. It's not inside the White House. It's basically next to the White House. It's not on government. Oh, everything's government property, but it's not on White House property. It's outside the White House. Just for you to know, the White House is about 1.5 miles from the Capitol. If you're walking at a reasonable pace, it's about a 40-minute walk, just so you get a sense of where the speech was given. On January 6th, Trump gave about a 2-hour speech. You can watch it. It's on YouTube, and maybe we'll get to some of the specifics later. The third area of conduct concerns what happened after Trump got off the stage. And the timing here is a little bit tricky because the incursion at the Capitol actually began, depending where you look, either while Trump was still speaking, or in some cases before Trump even began speaking, or in other parts after Trump finished speaking. In other words, there was not a single incursion at the Capitol, sort of just this sustained effort at various points of entry. So it's really hard to pinpoint exactly what the after is, and I don't want to even try to do it, but I'll just say after Trump got off the stage, what happened? And there are allegations that President Trump was watching the insurrection, if you want to call it that, at the Capitol, and he was smiling at the TV, saying, "Look at my supporters," right? And these are sort of these unsourced allegations, but this is in the record. There's allegations that President Trump frustrated the process by which federal military could be dispatched to, go to the Capitol to stop the rioting. Okay. I'm hedging my speech slightly because we don't exactly know what happened. We're relying on press accounts, which are probably accurate, but we just don't know for sure. Why do we really not know for sure? There were no hearings. In the past, when the House holds impeachment proceedings, they have lengthy hearings where they have witnesses testify under oath to try to develop a factual record. That was not done here, perhaps out of necessity. This was a rush impeachment. Basically, within, I think, 48 hours after the impeachment articles were introduced, they were voted upon. So there was no hearing. The House Judiciary Committee put out a report, which was, again, citing mostly news accounts and other public sources, but there was no hearing that was really present. Okay. Those are the three areas of conduct. Now, the House sort of merged those areas into one impeachable offense that they called incitement of insurrection. Incitement of insurrection. Now, there's a federal crime for incitement of violence, right? There's a statute for it. They didn't rely on that offense. There's also a federal offense for insurrection. The House didn't rely on that offense either. They relied on this sort of nebulous term, incitement of insurrection, which was really this sort of novel standard which they put together based on what happened in January 6th, which was a day, frankly, unlike any other in my lifetime and maybe anyone else's lifetime. Okay, so the House voted to impeach Trump while he was still in office. So the impeachment itself, the vote was held while Trump was in office. The first constitutional question I want to talk about is, when is a president actually impeached? And this might sound like a stupid question, but it's not. Some scholars contend that the president isn't actually impeached until the House managers walk over the articles of impeachment to the Senate. Right? You can say, Josh, why does this matter? Why is this even relevant? In the history, right, there's a very solemn ceremony where the managers basically march over the articles from one house to the other. It's a very, very rigorous procedure. They sort of walk very slowly. It's like a little theatrical thing. And generally, when the Senate receives the articles, they have to begin trying just about immediately or almost immediately. Right? They can debate a bit, but they have to start pretty quickly. There's some argument that until the articles are delivered, the president hasn't actually been impeached. Almost like a Schrodinger's president, right? Is he impeached or is he not, right? Or if I may, for Notre Dame, who's the real pope, right? It's unclear. It's unclear exactly when the impeachment begins. Now, the vote to impeach Trump was held while he was president. But the Senate did not receive the articles until after the inauguration, when Trump was no longer president. Why was there a delay? Politics, to be frank. At that point, when he was impeached, McConnell, the Republican, had the gavel. I think the Democrats wanted to wait till Schumer had the gavel, and that's currently the situation now. So there's some politics going on. I don't think this renders the process invalid for reasons I'll get to in a minute, but it is a difficult question of what happens when the impeachment actually happens formally after the person leaves office. In my view, Trump was impeached while he was in office, but I think you can credibly say he was not impeached while he was in office because the articles were not delivered. But I think you can make credible arguments on both directions there. Okay, now what next? Who exactly is being impeached, right? Well, Trump will assume was being impeached while he was president, but Trump is no longer president. You wouldn't know it. We're still talking about him nonstop, but he's no longer president, right? He is a former president. He's a private citizen living somewhere in South Florida. Okay. Can you impeach? And by impeach, I mean try. That's really what people are saying. Can you try for conviction someone who's out of office? And again, this is a question which most people never thought about. I've actually looked at this question some years ago, and I had to sort of chuckle when it came up. It's like, oh, yeah, here it is, another crazy Trump issue, right? It always happens that these obscure questions that law professors think about become real. Okay, so there's some precedent we can look to about trying former office holders. Perhaps most famous was a person named Belknap. He was a Secretary of War who was impeached. And as things go, he sort of resigned to try to avoid a conviction. But he was still tried in the Senate even after he left office. So there's some history in American history of trying a former officer. But that precedent isn't exactly on all fours, as law professors would say. In that case, you had a person who resigned for the purpose of frustrating the judicial trial. Here with Trump, he didn't resign to frustrate the trial. His term ended on January 20th, and he did nothing to leave early. So I don't know that precedent is directly dispositive, but I think I'll go along with the late impeachment for a couple reasons. First, in the British system, on which our system's modeled, there's a lot of history of late impeachment. So I don't think that's necessarily problematic, but I recognize there's not a clear answer here. Perhaps another reason why late impeachment might be favored is that there's another consequence of impeachment, which is disqualification, right? Under the impeachment disqualification clause, the Senate can vote to disqualify a person from holding certain federal offices in the future, right? So the first vote is to convict, and then usually there's another vote to remove, although some people say that the removal is automatic, and then there's the disqualification vote. Right. So even if a person's out of office, there's still consequences that could attach from the impeachment process, which is disqualification. Another reason perhaps why late impeachments are useful is imagine the president engages in some really egregious conduct the last day of his office. Right. Let's say he accepts a bunch of bribes and hands out pardons in exchange for bribes. Someone brings a suitcase full of cash to the White House on January 19th. He says, "Here, Mr. President, I want a pardon." And then the president pardons them. Right. It would not be physically possible for the Senate to impeach, try and remove the person in less than a few hours, although maybe they could. But it's still problematic. So I think the idea of late impeachment is not necessarily wrong, but I think we should just be cognizant that there's not clear answers here, right? There are a lot of difficult questions in this topic for which we should be cautious, right? We shouldn't try and say, of course, the answer here is clear, because it's not. Nothing I'm saying here, the answer is clear. If it was clear, I wouldn't be here. Right? We still have just a bit of humility to recognize that we don't know all the answers. And I hope, and if you take nothing else away from me today, is that just recognize we don't have all the answers here. Okay. Next question I want to talk about. Who presides? The Constitution says generally the vice president, that is the president of the Senate, presides at an impeachment, right? That makes sense. The president is, I'm sorry, the VP is the president of the Senate. He's generally the presiding officer. Now, let me give you a hypothetical. What happens if the vice president is impeached? Who would preside at that hearing? Would the VP preside at his own hearing? That's what the Constitution says. Or perhaps there's some unwritten rule saying the vice president cannot preside at his own impeachment proceeding, right? Professor Akil Amar has written about this issue in his book Unwritten Constitution, which you should all be familiar with. Okay, so that's the VP. What about the president? The Constitution says that the Chief Justice shall preside at a presidential impeachment hearing. Now, why? Now, the answer here may not be entirely obvious. If the president is impeached and removed, who replaces him? The vice president. So let me get this straight. The person who presides at the president's impeachment would replace him? Well, that's not fair, right? That can't be right. So the framers recognized that sort of conflict of interest, and they inserted someone else to fill that role. And they said the Chief Justice. Now, I'm going to blow your minds. That doesn't have to be the Chief Justice of the United States. That is John Roberts, right? I think Congress would designate someone else to serve as Chief Justice. There's no requirement that the presiding officer of the Supreme Court is the same person who leads the Supreme Court, right? That's not there. In fact, the Constitution refers to the judges of the Supreme Court, not the justices. So I think the word Chief Justice is misleading. In fact, in the British scheme, Chief Justice was a trial judge, not an appellate judge. So there's some evidence that this doesn't have to be the Chief Justice, John Roberts, but under our current system, it is. So last year when Trump was impeached, which is called Impeachment 1.0, we have an impeachment proceeding with John Roberts presiding. The Chief Justice took a very narrow role. He didn't want to break any ties. He didn't want to do anything. It's what he always does, do as little as humanly possible. But I think he comported himself quite well. This go around, Roberts apparently, we don't know, but apparently said, not me, like you're playing a game of tag with kids, not it, right? Roberts like, screw you, I did this already, not doing it again. I would have liked Roberts to explain why. He again doesn't like doing anything more than he has to, but he should have probably explained why, but he's not going to do it. And we've heard from Schumer and McConnell that Roberts said he didn't think he was the right person. Presumably, it's almost an advisory opinion. Roberts thought that he's not sitting president. I don't need to preside, right? There's not a risk that the vice president will become president here. So why am I doing this? Okay. So that would suggest that Kamala Harris, the VP, should preside. For very good reasons, she decided to not do it. I think it would draw her to this sort of political mess. And also, the most likely opponent for her in 2020 on the ticket would be Trump. 2024 would be Trump. So I think it makes a lot of sense to not have the sitting VP try to preside over this hearing. So who does it fall to next? Senator Pat Leahy of Vermont. He's the Senate President pro tempore. That is the most senior senator. He's in his 80s. He's been serving, I think, since 1974. He came to office after Watergate. I think when he was elected, he was 34. He was a very young man, and now he's in his 80s. But the Leahy one is tricky. Why? Leahy was a witness to the offense, right? He was in the Capitol during the riot. He will also be a juror voting to convict. And he's a presiding officer. So he's, the judge, the jury, and the executioner, right? So to speak. Is this unconstitutional? I don't think so. Does it feel wrong? A little bit. Is there anyone else who can do it? Not really. Maybe a reason why the chief should have stepped up, but again, he wasn't interested. Okay. So that's the process. In about 11 minutes, if my math is right, the House will vote on a resolution of whether to dismiss the prosecution. That is whether the impeachment itself is invalid because the president's out of office. That vote will fail. So that's the first one. So today's proceedings will have a few hours of debate and a vote, and then we begin tomorrow. That is Wednesday. Okay. Now I want to talk about the substance of the impeachment. And for full disclosure, President Trump's lawyers cited me and they quoted me in a few places, and they used my stuff even where they didn't quote me, which is fine. That's how things go. I've had no contact with them, but I'm happy they used my stuff. All right. The first substantive issue to talk about Do we need a violation of substantive criminal law? In other words, there is an incitement statute, there is an insurrection statute, but the article of impeachment didn't cite either provision. Is it invalid to impeach someone for violating something that's not an established offense? And I think the answer here is it's probably okay. And I'll give you a hypothetical. Imagine that George Washington, on his first day in office, murdered someone, right? Congress had never enacted any statutes. There was no federal law. Could he be impeached? I think so, right? This was a private act. He didn't use government property to do it. And I think you could rely on established murder law, perhaps the common law of murder at the time, or even the murder in the, I guess, in Philadelphia, the murder law of Pennsylvania or New York, wherever Washington happened to be, right? So I don't think you need an official offense. But I do think that when you have these sorts of private acts, you need some established law to rely on. You don't need a statutory offense, but something. You can't just make up an offense when you're dealing with these private acts, okay? What about public acts, right? The idea that Trump breached his oath of office or violated the public trust. Here, Congress has more latitude. Here we use what we might call fiduciary law to determine what duties does the president owe to the public, right? So I draw a distinction between these sort of private acts like murder, which you don't really need established law, and public acts like, violating your oath of office, which I think you have a much wider latitude. What exactly did this article of impeachment allege? Is it a public act or a private act? It's a little bit of country, a little bit of rock and roll. It's a little bit of both. I think there's some mixture of both. I think the private act is Trump giving the speech. He gave it outside the White House as a political speech. I don't think that's an act of his government. But also you have allegations that he used government power to not fight the riot. That is, he restricted the use of government personnel, or he made it more difficult for the military to intervene. Again, those are very difficult fact-based questions, which I don't think we have enough of a record to show. People might disagree, but I think the record there is tricky. For the Trump used his government power in a bad way, I don't think you need established law. You can sort of use a fiduciary model. But for a public speech given to constituents, I think you need something more. You need established law. And this is where the First Amendment comes in. Now, I didn't make up this notion that the First Amendment has relevance to impeachment. People think I did, but I didn't make it up. I've been researching this issue for almost 4 years. I've written a lot on presidential speech. In 1868, the House impeached Andrew Johnson in his last term of office. His last few months of office. What else is new, right? And one of the articles said that Johnson gave a number of speeches in which he basically brought Congress into disrespect, right? It was almost sedition. If you remember the Alien Sedition Act, this is the sedition part, right? You can't criticize the government. During the impeachment trial, a number of senators said that this impeachment is inconsistent with the First Amendment. Some said it was. Some senators said that this is fine. This doesn't violate the First Amendment, but others said it didn't, right? I'm okay with that debate, right? Whether it does or does not violate the First Amendment is a secondary question. In my mind, the threshold question is the president has First Amendment rights. And I think those rights pertain to the impeachment process as well. How they pertain is a difficult question. But I think the notion that it doesn't is wrong. Recently 140 law professors signed a letter saying that this argument is frivolous. If you actually read the letter, it's not exactly clear what they think is frivolous. It's a very muddled letter. But they don't address this history of the Johnson impeachment, right? The prosecutors thought that the article was fine, and some of the senators who voted to acquit thought it wasn't. I'm okay with that debate, but there is some long-standing history that the First Amendment provides some protection for the president. In my view, it provides a baseline, right? The president's an elected official. Whatever latitude free speech affords, I think the president should be afforded the greatest rights. You may study in First Amendment Pickering and Garcetti that civil servants have these very limited free speech rights. The president's not a civil servant. He's the leader of the free world, right? The president's exempted from the Hatch Act and various other restrictions for very good reason. You may think that, political appointments, right? The Secretary of State can be fired at will. Sure, he's an appointed official, but the president's elected. I think whatever the widest latitude is that people can get should be given to the president. Okay. So I really think under the First Amendment, the January 6th speech is bad for the House managers. We have this case called Brandenburg. which speaks of imminent incitement. And imminent means right now, now. If this were a criminal process, Trump could not be convicted. The Brandenburg standard is not satisfied if you say, walk peacefully and patriotically to somewhere 1.5 miles away. There's no way you get a conviction. I don't care what happens after the fact, right? That would not result in a criminal conviction. It's too far. Does Brandenburg apply in an impeachment proceeding? Again, I think as a normative matter, it should, that the broadest possible speech protection should govern. I recognize senators may disagree with me. I think that's a reasonable judgment, but I don't think it's frivolous for a senator to say it's a free speech problem. Okay. What about the rest of the allegations, right? The sort of failure to send out the military to timely put down the insurrection. That's much harder. You're basically saying the president failed to enforce the law to the extent you would have wished. That, in my mind, is what you might call maladministration, which is the president didn't enforce the law how you wanted him to enforce it. And one of the original drafts of the the original draft of the Constitution, it listed maladministration as a ground for impeachment. That was taken out. I think we have these when you have these discretionary acts of how the president exercises power, we have to be very careful about making that impeachable. I would want a very clear factual record that Trump knowingly and intentionally said, stand down, let the rioters in, right? If there's evidence of that, I think I'll give you a different answer. But if the evidence is Trump didn't want military people there because he thought it would look, too imposing to have the army staying outside the Capitol, right? There might be valid reasons, or might not be. But I think given the record here, I'm very skeptical. Okay, I am over time. That's my last point. Maybe I'll get to disqualification and Q&A, but I thank you for that, and I look forward to some comments and Q&A. Thank you so much. Okay, I think whoever, are you in mute there? Okay, there you are. Thank you. Yeah. Hello.
You should be good.
Yes, I can hear loud and clear. Thank you.
We'll have Professor Brule speak, and then we'll have about 5 minutes for about speakers as well.
Well, thank you for your comments and remarks. It's unfortunate that you weren't able to join us in person. Hopefully we'll have that opportunity in the future to have you visit at some future date. Well, let me begin with some very fundamental principles and then work on more specific issues that are raised by this issue with respect to the impeachment of former president and whether that is constitutional. So first and foremost, let's not lose sight of the fact that our democracy is based on the rule of law. And a fundamental tenet of the rule of law is known as voting, including the President of the United States. And I think that very basic fundamental tenet is implicated here today. But apparently 45 Republican senators do not fully adhere to that principle and are prepared to offer Trump a pass and not hold him accountable for this alleged, again it's alleged, alleged gross abuse of power. Apparently these senators do not want to confront the reality of what happened on January 6th. And looking for a reason, they claim that impeaching a former president is unconstitutional. And instead, they advise us that it's time to move on. It's time to move on. And my response to that is, really? It's time to move on? Let's step back and recall what the president has been alleged to have done. He's alleged to have committed a gross and egregious abuse of power. Incitement of insurrection. So just kind of let that sink in for a second. The President of the United States has been impeached for incitement of insurrection. On a scale of different offenses involving abuse of power, where do you think this fits in terms of the most egregious to the least egregious? At least for me, for my own personal opinion, I can't imagine an abuse of power that is more egregious than that other than treason. So I would put this one step below treason. That's how serious the allegations are. That the Senate, these Republican senators, are asking us to move on and not debate during the trial. Congressman Liz Cheney, the third highest ranking GOP leader in the House of Representatives, stated, and I quote, this isn't a flaming liberal, it's a conservative Republican congresswoman, and here's what she stated. The President of the United States summoned this mob, assembled this mob, and lit the flame of this attack. Everything that followed was his doing. And the his is referring to, of course, President Trump. None of this would have happened without the President. The President could have immediately, he did not. There has never been a greater betrayal by a President of the United States of his office and his oath and Constitution. So let that sink in. Let me repeat that because I want to emphasize, I want to make sure that we understand this. Liz Cheney said, Congresswoman Cheney said, there has never, meaning in the history of this country, ever been a greater betrayal by the President of the United States in his office and his oath to the Constitution. So that's what we're talking about. That's the center of what we're talking about. This is what five senators are asking us to look past and move on. Well, the impeachment clause is silent on whether the Senate can try a former president. Take a close examination of the text, the history and purpose of the impeachment clause, historical practice of impeachment in the United States, and a common sense argument to fully support an impeachment of President Trump. Starting with the text, Article 1, Section 3, Clause 6 states, the Senate shall have the sole power to try all impeachment. And I submit to you that all means all. Not just impeachments where the president was impeached while sitting in office. The argument here is, well, he was impeached while sitting in office, but he's no longer the president, and so the Senate can't try him for that impeachment. They can't try because he's no longer a sitting president. Well, that seems to me to run counter to the express language of this particular provision, Section 6, Clause 6 of the Constitution. The Senate shall have the sole power to try all impeachments. Professor Sugarman, a professor at Fordham Law School, has argued Trump has been constitutionally impeached. He was at the time of this impeachment an incumbent president, and the House has resolved by majority vote to impeach him. And therefore, this is a lawful impeachment. Professor Michael McConnell, distributed constitutional law professor at Stanford Law School, stated Mr. Trump was impeached while still in office, and accordingly, the Senate has the power to try the impeachment. There's an additional clause of the Constitution, article of the Constitution is relevant, and it was been alluded to by Professor Blackman. Judgment, and that's Article 1, Section 3, Clause. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification. To hold and enjoy any office of honor, trust, or profit under the United States. So here, the Constitution sets forth two different forms of punishment. And so if the president is impeached, then he's automatically removed from office. And then if the Senate chooses, they can impose an additional penalty of disqualification to disqualify you from ever holding office again in the United States. And with respect to that provision, the disqualification provision doesn't kick in until the president is impeached and he's removed. And so if you take the, given that the Constitution permits the Senate to impose a penalty of permanent disqualification only on former office holders, it applies logic to suggest that the Senate is prohibited from trying and convicting former officers. That's actually a statement from Chuck Cooper, Chuck Cooper is a conservative constitutional law scholar. Again, he's the one that's making this statement. And he, in 2010, the Republican National Lawyers Association named Cooper the Lawyer of the Year. And they called in that high esteem. And in fact, at that event, Secretary Bolton, former Attorney General Meeks, and Wayne LaPierre, the former president of the NRA, spoke in support of Cooper's nomination or award as Lawyer of the Year. So that's what he says on the topic. Professor Tribe, on the opposite end of the ideological spectrum, here's what he had to say, and I quote, "To render this uniquely appropriate remedy unavailable, simply because the gravest abuses of power were committed near the very end of a president's term would be bizarre at best. Sabotage at worst. Nothing in the Constitution suggests that the president, who has shown himself to be a deadly threat to our survival as a constitutional republic, should be able to run out the clock on our ability to condemn his conduct and to ensure that it can never occur." So it's interesting. You have constitutional scholars on both ends of the spectrum that to maintain that a president can be impeached after he leaves office, and that the disqualification provision supports that view. So history, and there's been a little bit of comments reference to history. Found to borrow this power from British parliamentary practice, which does not suggest that the power to impeach is intrinsically limited to the incumbent officer. So basically, at the time that the framers were debating the Constitution, the British Parliament, I mean, its application, its understanding of impeachment was very broad, and it extended to former officers. So it was within that context that the framers were discussing the impeachment clause and what it should look like and how broad it should be, how limited it should be. So this wasn't a foreign concept to them at all, impeachment of former officers. In fact, it was the general rule. I mean, it was permitted, it was recognized. And so it seems to me that the framers disagreed with that kind of broad, here's the way we do it, in the UK at the time, that they would have included some language to limit the application or the impeachment clause, to limit it from kind of firm status at the time, of course, they did not. Constitutional Convention in 1787 had been Randolph, who identified the danger of presidential misconduct and insurrection, said, guilt wherever found, wherever. So there's clearly no time limit, former president limitation on the impeachment clause. We know that former colonial governor of India, Warren Hastings, was impeached in Great Britain, led by Edmund Burke, and the framers repeatedly referenced Hastings' impeachment during the Constitutional Convention. Of course, Hastings was impeached after he left office. So that's history. Then we look at practice of impeachment. In 1846, former President John Quincy Adams declared with respect to impeachment, quote, "I hold myself, so long as I have the breath of life in my body, amenable to impeachment by this House for everything I did during that time I held any political office. I hold myself so long as I have the breath of life in my body, amenable to impeachment." So clearly beyond, simply the period of time that he would was holding office. There's already been a reference to Secretary of War Belknap, so I won't go over that. Again, Circuit Judge Robert W. Archibald was impeached, tried and convicted for corruption in office. And the articles of impeachment included his behavior in his previous position of a district court judge, position that he had since left. He was a judge at the time, but the crime for which he was impeached, or the article of impeachment related back to conduct that occurred in his prior position, which he has since left. So I think that's another example of the practice in the U.S. with respect to impeachment. Now, it's been said that the purpose of impeachment, the sole purpose of impeachment, is to remove from office an individual. And so, the argument here, well, that's happened. It can either happen by force or removal by the Senate, or if the officer voluntarily, steps down, in this case, not be elected to office. So, the argument is, well, that's the purpose of impeachment. That objective has been achieved. He's no longer in power. And so what's the big deal? Let's move on. Why do we need to hold this impeachment trial? Well, the concern, of course, and the concern that the framers had was that that same individual may decide to run for election sometime in the future. And so in order to protect the state from this corrupt individual that either was removed by the Senate or left office on his own accord, that we needed a disqualification punishment to prohibit him from ever holding office again. And so again, I think that's why we have this trial. President Trump has stated on more than one occasion he is considering running for re-election. He wants to assume that power and authority once again. Certainly could see himself, challenging the Democratic candidate, whoever that is, in the next election. So this disqualification is necessary to ensure that the individual has no opportunity to do similar harm in the future. So I think impeachment is important for that purpose. In addition, I think that there are at least two other important purposes that would be advanced by the impeachment of President Trump. One is referred to as kind of the grand inquiry. The argument is the impeachment process is a grand inquiry by Congress exercising its oversight powers over the executive branch. I don't know that I would characterize it that way, but I do think it has to do with educating the public regarding corruption and public corruption. And I know we've all been bombarded by these images that we've seen that have been publicized by the media regarding what occurred on January 6th. But I think that there is still additional evidence, additional facts that should be shared with the public so that they get the full, complete picture of President Trump's conduct, what he did and what he didn't do on January 6th, as well as the months leading up to the January 6th event. So I think that there's some value here in transparency and educating the public as to the wrongs that were committed by the president. And then second, I think an additional value for impeachment is deterrence. By clearly and decisively condemning certain actions as intolerable within the American system of government, Congress not only purges a particular malefactor, but also attempts to purge the misdeeds from the system and set up a prophylactic to prevent their recurrence. As I would have said, that was one of the academic, one of the constitutional professors supporting impeachment that made that statement. And then lastly is the common sense, ends of justice argument. As Professor Call has pointed out, this rule that you can't try a former president, the Senate can't try a former president. Professor Call has stated, this rule would have the perverse effect that guilty officials would be able to avoid disqualification, which would put the process of disqualification entirely in the hands of the accused. So the accused could engage in this game. So the accused could wait, let the trial proceed. If the evidence doesn't look favorable to the accused, 10 minutes before the Senate is to take a vote on impeachment and removal, then the public official, in this case the President of the United States, said, well, I'm just going to resign. I'm going to resign, and because I've resigned, I'm no longer the city president, and therefore I can't be disqualified. because you can't have an impeachment on disqualification, hearing on disqualification, because I'm a former officer. So that would be the perverse effect of this. The professor called refers to basically would leave disqualification in the hands of the accused. I believe it was Professor McConnell that stated it would be odd to say that only a president who succeeds committing election fraud should be impeached and disqualified. But a president who tried and failed should be immune from disqualification. Quoting the Trump's team, I believe this is from Charles Cooper, Chuck Cooper, the Trump team's version of impeachment believe the process easily be. Why wouldn't every official know this is actually another commentator who made the statement? The Trump team's version of impeachment would leave the process easily be. Why wouldn't every official facing the likelihood of conviction simply resign from office 10 minutes before the Senate votes? Would this make the second punishment disqualification from future office impossible to impose? End quote. I think that's what we're looking at. I think that's what the Republican senators, the implications of the argument positions the Republican senators are taking. Disqualification would be imposed on an official who they have a chance, of Senate acquittal, decide to risk a vote and then lose. Those who were confident of the Senate conviction would always avoid disqualification by strategically resigning. Therefore, the worst offenders would never face disqualification. So in the end, the position advanced by those that claim the president, the former president, can't be tried for impeachment, what are the legal consequences? What are the legal and policy consequences? One, no disqualification, no deterrence, no grand inquest, and no accountability. In my opinion, this would be a perverse result and a perverse conclusion with respect to the rule of law. It would pervert this fundamental rule of the rule of law, and no person is above the law. We'll stop there, and that's our biggest achievement.
That's the truth, Mr. Watson. I think that's right. We can write Q&A, so you want.
Well, I think we've only got about 10 minutes.
Yeah, let's go right to Q&A, and maybe I can work in some of my responses when students ask questions. So thank you very much.
So who wants to, are you taking the chat?
Yeah, I'll check out. Is there any, I guess.
Okay, well, let's start with the audience. Okay, you want to have any questions? Or either Mr. Black or myself? Somebody better have a question. I'm not going to be happy. These are big issues, these are weighty issues, complex issues. Mr. Blackman had identified about a dozen of them as complex. Many of them are not resolved, open issues. First time in history, we have a president been impeached twice within a year. And so somebody better have a question.
I see Kevin has a question. Kevin on the queue.
We've got one in the audience. Go ahead.
All right. So my question is for Professor. I'm not really sure as to your last name. I'm sorry, but Euro, I think. I was just wondering, what your opinion was on what Professor Blackman mentioned about who should decide. You mentioned the different possibilities being Pence, Roberts, or Harris, or the pro tem. But I was just wondering what you thought about that, and what your opinion was.
Well, I think we want to make sure. I think what I would agree on this point, that whoever presides should be an independent, impartial officer. And so that impartiality is lacking when we have a member of the Senate, even the longest serving member of the Senate on the Democratic side, right? And especially when that individual was at the crime scene, which is the House of Congress, at the time when the insurrection took place. And so I would prefer, I would strongly recommend that the Chief Justice of the United States be the presiding officer. First of all, it's a big deal. Talking about impeaching the chief law enforcement officer of the country, the President of the United States, commander-in-chief. And for Chief Justice Roberts to say, well, no, I don't feel it. Or, you know what, he's no longer the president, and my reading of this particular provision of the impeachment clause is that the Chief Justice presides over impeachment of the president. Trump is no longer the president, so I get to sidestep that responsibility. So I don't know that I think that maybe the Democrats are a little bit too kind here with respect to inviting Chief Justice Roberts to provide, which is what I think he did. And I think it should have been, we won't, we're expecting to hear. And
Yeah.
we want to preside over this.
And let me add a related point. Why are impeachments tried in the Senate? Right? Why would you not try the impeachment in the Supreme Court? This is something that Hamilton discussed in the Federalist. When you're impeaching the president or any high-level government official, you need a institution with gravitas, with heft, with enough authority to actually make it stick, right? The reason why you have a Senate impeachment. So I'm not entirely troubled by Pat Leahy, the Senate President pro tem presiding. I don't think it's the end of the world. I think Pat Leahy has more political accountability than John Roberts. But I think I share Professor Grell's concern that you're both a witness, a juror, and the presiding officer. That is problematic. So maybe if Leahy didn't cast a vote, but there's practice here. There's past practice where president pro tems have presided, and they've cast a vote to convict. So, this is a case where there's precedent, I think, on both sides.
Any questions from the audience?
We're gonna have a minute go.
Hello. Yes, so we heard this argument floating around kind of the last impeachment that a president can't be convicted of a crime while they're in office, and that the reason for impeachment is to remove that protective layer of the presidency from a guilty party. So that way, once that layer is removed, they can then be convicted of the crime that they have made committed in office through the normal criminal proceedings. So when we're saying that, there is no justice if a president were to commit a crime in the last days of office, doesn't that preclude the possibility that they could be convicted of a criminal charge once they have discharged their office? So in like a bribery example or in an insurrection example, if they violated that statute, what would prevent afterward from being a disqualifier from future office?
Sure. Well, excellent question. And maybe Kevin, put yourself on mute. Okay, thank you. The long-standing position is that a president cannot be tried for a crime while he's in office. Can the president be indicted while he's in office? Closer call. But I think people agree you can't try the sitting president. But there's nothing stopping the D.C. Attorney General or even the subsequent U.S. Attorney General from seeking an indictment against a former president if the president engaged in a crime. There's certain statute of limitation issues, which I don't think we present. We're well within the stat. We're barely a month out. So I think you could try Trump for insurrection or try him for inciting a mob. I don't think those convictions would stick. I don't think what he did violated the criminal law, which is why they're going with the impeachment process, which is something greater. You're saying he violated his oath of office, and that's a phrase thrown around, but it's circular, right? What is the office? What are the duties, right? What exactly is this obligation? And I think it's a difficult question. You can't just say, oh, he violates oath of office. Of course, it's obvious, right? There's got to be some there. But yeah, the fact that you can try him for a crime afterwards is there. But just keep in mind, a convicted felon can run for president. Eugene Debs, famous socialist, ran for president many times, right? You can be a criminal and run for president. There's no disqualification. So the only way to impose a disqualification is through the impeachment process.
Well, I guess my response is that the framers favored or at least intended impeachment. And we know that impeachment is a political process. So it's not illegal. It's not illegal in the sense of a criminal prosecution. The same rules and procedures that here that apply in federal district court, are well granted, due process exists, but again, the specific procedures, hearsay, rules of evidence, and so forth. So the framers intended this political process, and if we take this kind of this prosecuted later in federal district court, conceivably you take that into account. Why even have impeachment? You can always just wait and hold accountable after that. So that's not what the framers intended. historical perspective, think about the reality of what that criminal prosecution would look like. You've got 12 members, 12 citizens that are sitting to decide the criminal fate of a former president of the United States. That's an incredible burden to place on those citizens. And I wonder how difficult it would be for them to, I mean, wouldn't it be kind of in the back of their mind, geez, you really want to, find this guy guilty of a felony, And so I'm not so sure in practice how that would actually play out. Is it an option? Yeah, it's an option. But I don't think that it should supersede the political process that was set forth in the.
I'm Max Nikitas on the 1L. I think Professor Gourlay makes a very compelling point about the constitutionality of impeaching a former president. Professor Keith Whittington of Princeton made that argument in the Wall Street Journal article in January, noting how the founders actually believed in the superiority of impeachment provisions in the federal constitution because, unlike the state constitution, you even impeach a current official. So that shows you where the assumption was that clearly. But my question is for Professor Blackman. I think the First Amendment argument that you made is very important as well. But wrapped up in the idea of incitement of insurrection in the articles themselves is also the notion that the president violated his constitutional oath, right? That he was defenestrating the Constitution to allow this mob to come and to nullify the will of the people, and also to exhort the Vice President of the United States to assume a role that he did not have in the Constitution. So part of the incitement of insurrection is also, I think, is a violation of his constitutional oath. And while you concede that you don't need to violate the statutory right to be impeached, it seems like the First Amendment argument is actually geared towards saying, well, he didn't actually violate the statutory right. To me, the First Amendment argument would be more compelling in the context of the Section 3 of the 14th Amendment, if you're trying to disqualify him from future office on that basis, because that would be grounded in establishment. So what is your response to that argument? Do you think that the First Amendment argument is still more applicable here than under the 14th Amendment?
Oh, I didn't even get to Section 3. Maybe if we have time later, I'll get to it. But let me just limit to the impeachment proceeding that we have. I think you have to separate the conduct. I think the speech given the Ellipse was not a governmental act. I don't think that violated his oath. He was giving a speech to constituents, which politicians do all the time. I think the First Amendment should govern there. If you want to impeach the president for a speech he gave to constituents, you need to deal with the First Amendment. Other conduct, perhaps that came before the speech and after the speech, would not be a public act. So it would not be a private act. It'd be an act of government. He used the levers of government to fail to defend the Capitol. When you're dealing with those, I think you don't have to rely on established law. You can turn to the sort of fiduciary duty. But I think you have to define it well. President Trump held a view of the Electoral Count Act that I think was wrong. Dead wrong. He thought that that VP Pence could turn it around and give him the election, right? I think it's an insane view, but it's a view he held. I don't think merely exhorting his constituents to follow his view of the Constitution is a violation of the oath of office, right? Merely holding that view is a contestable legal view, one that I think is quite wrong, but I would not impeach him for it. I think in order to make the impeachment stick, you have to say he incited that mob, and those are his public words, right? Those are the words he said in front of everyone. I don't think the sort of machinations after the fact would be enough, because I'm watching the videos now. I have many monitors. People were mobbing the Capitol before he even began, right? So I think you have to sort of separate these different elements. If there's evidence that he said, you know what, I want my supporters to mob the Capitol and I want them to enter, therefore I'm telling my people, stand down, do not send aid, do not send military. Okay, I'm with you. I'm going to go along with that. But I think you need to show that. It can't just be he had a sort of, maybe he sort of set back and did nothing, right? So, I'm not going to do anything now, or maybe he smiled at the TV. I don't think that's going to be enough. But thank you. Really excellent question. I don't think I have time for Section 3. Maybe we'll come back another day and debate that, but I don't have time for it right now. We're almost out of time.
The First Amendment argument is really sorry. What they're claiming is that his statements, again, there's reasonable minds may differ on this, whether they actually constitute incitement of insurrection. But the claim is, well, these statements are protected by the First Amendment. Well, that would be like saying what? Well, statements made by a co-conspirator in furtherance of the conspiracy, they're protected by the First Amendment? I mean, I don't get it. I mean, these are criminal statements. If they rise to the level of incitement, and again, we've got this Brandenburg test. And by the way, it's even an issue whether the Brandenburg test applies, because again, that's a legal standard for this legal crime called incitement. So we're pursuing this political process called impeachment. And impeachment is largely about abuse of power. So I don't know that the abuse of power has to necessarily satisfy the contours of each and every element of a federal criminal offense to justify impeachment. It's abuse of power. In the same way that these statements in furtherance of abuse of power, encouraging people to go to the Capitol building to thwart, delay, obstruct the electoral college vote, to prevent President-elect Biden from being elected president. That's protected speech. I mean, that's for me kind of, I'm not buying. I think these are criminal statements, furthering the criminal objective here. Their statements are kind of raise or the body of crime here of incitement. And I'm not buying that those are protected by the First Amendment.
So we are about out of time, but I did get one question submitted anonymously. So maybe each of you could give a quick answer. Impeachment has been described as a political process. Could President Trump challenge his impeachment in court?
I'll field that one. The general answer is no. There was a case called Walter Nixon versus United States. This is not President Nixon, it's Walter Nixon. He was a federal judge who argued that his impeachment process was invalid. And the court basically said that this was a non-justiciable political question, right? We're not going to decide if impeachment was valid. But, and here comes the big but, disqualification is not a political question. If the Senate tries to disqualify Trump and he tries to hold some other office in the future, I think it's justiciable, right? Let's say a Secretary of State keeps him off the ballot, or a state election board keeps him off the ballot. I absolutely think that's a question the court's going to have to resolve. A student asked a minute ago about Section 3 of the 14th Amendment, right? What if the House passes a resolution saying he's disqualified from holding future office? I think that's absolutely a question a court could have to decide if there's a future, if Trump goes on the ballot in the future. So the short answer is no, it's not justiciable in the abstract, but the consequence of disqualification would be. So my friends, we are not done with this question. The Senate cannot define the scope of disqualification. They can vote on it, but it'll be up to a future court to decide whether disqualification is valid.
Can we all give a hand to our speakers?
Thank you so much. Thank you, everyone. I'll see you all soon. And let's see how many people are in this beautiful. I've been in this room before. It's such a nice room. You're spaced out so well. Good for you guys. Thank you so much. And I look forward to talking to you all soon.
Thank you.
He was president. There can be no doubt that this is a valid and legitimate impeachment. And there can be no doubt that the Senate has the power to try this impeachment. We know this because Article 1, Section 3 gives the Senate the sole power to try all impeachments. The Senate has the power, the sole power, to try all impeachments. All means all, and there are no exceptions to the rule. Because the Senate has jurisdiction to try all impeachments, it most certainly has jurisdiction to try this one. It's really that simple. The vast majority of constitutional scholars who studied the question and weighed in on the proposition being advanced by the president, this January exception, heretofore unknown, agree with us. And that includes the nation's most prominent conservative legal scholars, including former 10th Circuit Judge Michael McConnell, the co-founder of the Federalist Society, Stephen Calabresi, Ronald Reagan Solicitor General Charles Freed, luminary Washington lawyer Charles Cooper, among hundreds of other constitutional lawyers and professors. I commend the people I named, their recent writings to you in the newspapers over the last several days. And all of the key precedents, along with detailed explanation of the constitutional history and textual analysis, appear in the trial brief we filed last week and the reply brief that we filed very early this morning. I'll spare you a replay, but I want to highlight a few key points from constitutional history that strike me as compelling in foreclosing President Trump's argument that there's a secret January exception hidden away in the Constitution. The first point comes from English history, which matters because, as Hamilton wrote, England provided the model from which the idea of this institution has been borrowed. It would have been immediately obvious to anyone familiar with that history that former officials could be held accountable for their abuses while in office. Every single impeachment of a government official occurred during